Good afternoon, everyone. Welcome to the first of two panel events that we'll be hosting on making national security safe with Chris Whitecross, who's with us today. For those who were at the Ottawa conference in March, you probably recall that we had made a plan to do some work and research and events on these important issues. And so this is part of our delivery on that, and there will be more coming up. And we are intending to make a point of raising the issue once again next year at the Ottawa conference in March, which will be the 90th anniversary of the Ottawa conference, no less. For those who are not very familiar with the Conference of Defense Association, I did want to say a few words to get us started. First of all, that it's 40 member associations who represent over 400,000 active and retired members of the Canadian Armed Forces, and that its institute is a charity organization that conducts research and analysis and education programs. I guess what we try to be above all is a space, a forum where the community of people who care about Canada's role in the world can come together. And we try to foster and promote a facts-based and rational approach to defense and security policy in this country. Now, I think if we're going to call this a forum, we should definitely be trying to create as much engagement as possible. So that's why we do have a Q&A segment for the last 20 minutes or so of the event. In order to ask a question, what we'll ask you to do is just type it in at the bottom of your screen, and there's an opportunity for everyone who's present today to upvote their favorite question. So what we'll do behind the scenes is we'll feed the best, most upvoted question to our moderator, Chris Whitecross today. Yeah, hopefully we'll get a great conversation out of this. I guess one thing I'm supposed to do every time, and for sure I won't miss the opportunity, I need to be thankful. There's a lot of sponsors and partners who are involved in making these events happen. So first of all, Metro Supply Chain Group. It's our signature sponsor for today's event, for the webinar series as a whole, actually. We also have our strategic partners, RBC Insurance, ADIA, Dataminer, KPMG, Lockheed Martin, Logistic Unicorp, Raytheon, Thales, and WSP, as well as our operational level sponsors, ATCO and Microsoft. So thank you very much to all of these companies for helping us out and making this possible. And finally, I want to give a special welcome to Lieutenant General Christine Whitecross. She's the former Chief Military Personnel of the Canadian Armed Forces. I think everyone is very familiar with her in this audience, no doubt. First woman in Canadian history to reach the rank of 3-star. Now, a little bit about her background and career. In 2015, she was appointed as commander of the Canadian Forces Strategic Response Team on Sexual Misconduct when she assumed the duties of Commander Military Personnel Command. And she soon thereafter was sent to the NATO Defense College in Rome and retired from Canadian Armed Forces on her return to Canada in 2020. Now, she's also a very valued member of the CDA Institute community. In 2018, she was the laureate of our Vimy Award, which celebrates a Canadian who has made a significant and outstanding contribution to the nation's defense and security and to the preservation of our democratic values. And since April this year, she's joined the CDA Institute Board of Directors. So it's a real pleasure for me to hand it over now to Christine Whitecross. Thanks for being here and taking the lead on this important initiative.
Thanks very much, Yuri, and good morning or good afternoon, depending on where you are. And welcome to this webinar on modernizing military justice. As you heard, my name is Chris Whitecross, and I am absolutely delighted to be the moderator for this panel. There is no question that the military justice system has seen some changes in the last few decades, and that these in turn influence or affect the members of the Canadian Armed Forces. Two such changes include the implementation of Bill C-77, involving the implementation of the Declaration of Victim Rights within the Code of Service Discipline, as well as potential changes as identified in the recently released third independent review of the military justice system, commonly referred to as the Fish Report, which has brought on debates about how this system operates and ensures that the Canadian military maintains its morale, efficiency, and discipline. I anticipate that this panel will help us to engage in a discussion of how the military justice system operates, what changes it is facing, and what this means for Canada's military and its military justice system. We will be touching on topics such as the Fish Report, the independence of the military justice system, sexual misconduct, and hateful conduct, amongst other things. I believe our speakers today will help put some context around this issue, while also helping to whet your appetites for conversation on the topic. First up, will be retired Major General Blaise Cathcart, a former Judge Advocate General for the CAF from 2010 to his retirement in 2017. As JAG for more than 7 years, Blaise was responsible for advising the Government of Canada, Their Excellencies, the Governor Generals, and the Department of National Defence Deputy Minister, as well as the Canadian Armed Forces Chief of the Defence Staff, on matters of military law, and was concurrently the Superintendent of the Administration of the Canadian Military Justice System. Blaise has a breadth of knowledge and experience in the areas of operational and international law at both the strategic and operational levels. He is a graduate of the Dalhousie Law School and has a Master's of Law degree in Public International Law from the London School of Economics and Political Science. Blaise is currently an adjunct professor of law at the University of Ottawa Law School and a senior fellow for the Lieber Institute for Law and Land Warfare at the United States West Point Military Academy. Blaise is going to open the discussion and give us some context on how the military justice system operates and what changes it will be facing. Following Major General Cathcart will be Mr. Guillaume Charlebois, an associate in the dispute resolution group of Davis, Ward, Phillips, and Weinberg. Mr. Charlebois' legal practices focus on complex matters that often involve public law ramifications, including class actions dealing with human rights and crown liability. He obtained his law degree from the Université de Montréal and his Master's of Law from the University of Cambridge. Of import to this panel, Guillaume counsel to the Honorable Morris J. Fish, former Justice of the Supreme Court of Canada, in the context of Justice Fish's appointment by the Minister of National Defence as the authority tasked with conducting the third independent review of the National Defence Act. Guillaume will be speaking to the newly published Fish report, specifically putting it into context and by familiarizing us on how the conclusions were developed. Guillaume will also summarize some of the main recommendations. And by no means last, our final panelist, Dr. Leah West. Dr. West is an assistant professor of international affairs at the Norman Paterson School of International Affairs at Carleton University. Her focus is in the area of national security law, and she completed her Doctor of Law in 2020 at the University of Toronto Faculty of Law, where her research explored the application of criminal, constitutional, and international law to state conduct in cyberspace, a topic that she regularly lectures on. Leah previously served as counsel with the Department of Justice in the National Security Litigation and Advisory Group, where she appeared before the federal court in designated proceedings and the Security Intelligence Review Committee. Prior to attending law school, Leah served in the Canadian Armed Forces for 10 years as an armored officer, where she deployed in Afghanistan in 2010. Leah will be speaking about those friction points of where the military justice system does and does not work due to cultural issues. Blaise, Guillaume, and Leah, welcome to the panel. Blaise, how about you start?
All right. Thank you for the introduction, General Whitecross, and hello to the fellow panelists as well. I want to start, obviously, by thanking Yuri and the good folks at the CDAI for creating this panel and inviting me to speak. It's critical to my perspective that we have these discussions in a very public way about military justice. Certainly when I was JAG, I worked hard to try and have a broader public discussion, not only in the wider legal community, but in the wider Canadian public, because I believe for the most part, most folks in the Canadian public don't know much about the military justice system, and probably hearing a lot of differing views and opinions, largely through media and spokespersons and people of that sort. So again, great to be here. I hope I can contribute, and hope we have a good discussion. To start off, I guess my role will be just to, for those who don't know necessarily too much about it, what the military justice system is. It is a separate and parallel system to the civilian justice system in Canada. It's on the same footing in terms of legal basis and constitutionality. It's recognized in the Canadian Charter of Rights and Freedoms. And we that from that perspective, people will keep that very much in mind as we have these various discussions. because I think for the most part, when you do hear about military justice in the last number of years, it's often been a negative comment. Many commentators and critics saying that the system is broken and it doesn't meet the needs of Canadian Armed Forces members. I strongly disagree with that, and I hope to articulate that as we go through today. But I think it's key to start from the first principle of there is a separate system, and that separateness has been recognized and created by Parliament, not by the military. I also want to acknowledge that the separateness and legitimacy of the military justice system has been acknowledged and confirmed several times by the Supreme Court of Canada, and we can talk about specific cases later on. But I think that's a very important piece to start with, that there is a separate system and there is a reason for that. And that reason, as General Whitecross has already alluded to, is to maintain the discipline, efficiency, and morale of the Canadian Armed Forces. And the reason to do that is because certainly in a democratic society like Canada, our Canadian Armed Forces exist primarily to defend our citizens, and that requires a ready and fit force to do so. And that can span a number of activities, as we've seen, not only what are considered high-end combat functions, as in Afghanistan, but also helping at home in domestic scenarios with floods and hurricanes, things of that nature, and assisting in other countries when they have natural disasters, and of course, contributions to UN peacekeeping, peace enforcement missions. So in order to maintain that modern, ready, battle-ready force, you do need discipline. And why do you need discipline? Because in order to have soldiers react properly under those stressful situations, you need to have them understand the importance of the obedience and the habit of obedience to lawful orders given to them. There are many tools in the military toolbox to help do that, but primarily, as we're focusing on today, the military justice system exists to do that. And as I've said, that's been confirmed multiple times by Parliament and by the Supreme Court of Canada. So like any justice system, it's not perfect. I certainly wouldn't be here to argue that. But I believe strongly that it is one that has evolved over the years. Hence the focus today on modernizing it. I don't want to leave anyone with the impression that modernizing it needs to start today, this week. It's been ongoing for decades, frankly, from the time that the Canadian system made a major switch in the 1950s from an all British system, which was truly command and military focused, and a number of changes, including the creation of National Defense Act, and within that act, the Code of Service Discipline, which is the main body that relates to Canadian Armed Forces members and sets out the various charges and procedures and processes for dealing with people under the military justice system. There has been a number of evolutions since the 50s. Many have been more recent, but there have been a number of very important evolutions that have occurred. And the reasons you do that, just like in the civilian justice system, is to keep a pace of society's expectations, not only of its own citizens, but more specifically of the members of the Canadian Armed Forces. If you don't keep pace, and you've got major issues, not only in changes to things like the criminal law, the Criminal Code of Canada, but also, for example, in 1982 with the creation of the Charter Rights of Freedoms and bringing home the Constitution of Canada. These were major changes for the entire justice system in Canada, and of course the military no less. But the military had to adjust in a different way than the civilian system, and they've done that through many different iterations over the years. So for example, to show that it has been a fairly active role, from my perspective, one of the biggest changes that occurred was after the infamous Somalia affair in the early 1990s. And a number of aspects, negative aspects, came out of not only command culture in Somalia, but individual discipline and unit discipline, and a breakdown that led to some bad scenarios, and ultimately a very tragic one with the death of a young teenager, Shadane Aron. And so the government of the day felt it important to have a number of ways to look into what happened, and in particular focus on the justice system. There was the best focus from my perspective of that was the former Chief Justice of the Supreme Court, Brian Dixon, who did a report to Parliament there. All these changes that were recommended following the Somalia affair and the Somalia inquiry and other inquiries led to the creation of 1998 of Bill C-25, which really fundamentally altered the military justice system. And when I talk about the military justice system, I'm focusing on primarily the two types of tribunals that currently exist. One is called a summary trial. That's where there's not a courtroom involved, no lawyers, no judges. It's a more of an informal process where the commanding officer sits in judgment of a charge laid against a member of the unit. And there are no specific rules of evidence. And the design of this tribunal is to deal with minor offenses in a rather speedy way. Then there's the more formal court-martial system, which is more akin to a civilian criminal trial for comparison purposes. And it consists of two types of tribunals itself. One is called a standing court-martial, which is a judge alone, and then a general court-martial, which consists of a panel of 5 officers, senior officers, and perhaps down to senior NCO sergeant level. And they act it's not the same as a civilian jury, but much like it, they determine the guilt or innocence on a unanimous basis. And at the same time, there's a military judge that advises the panel on the law, etc. So in this tiered system, there were fundamental changes to the system by Bill C-25, and including in that was the creation of what are now referred to as independent reviews. We mentioned one by Justice Fish. The first one done was by the first independent review by former Chief Justice Antonio Lemaire of the Supreme Court of Canada. That was in 2003 when his report was filed. Following that, there was bills made in response to that. Unfortunately, with the number of governments that were minority governments in that time frame, a number of the bills just died on what we call the order paper and didn't make it through. So there was a large delay in getting those changes done. And then we had a number of other bills coming out at the same time, Bill C-60, which changed the court-martial structure in response to a court-martial appeal court case to give greater selection to the accused over what type of court to deal with. Bill C-16 in 2011 dealt with military justice judges and their tenure, how long they can stay as a military judge in the military. And then more recently, we've had Bill C-15, which is another major change, mostly, again, implementing a number of the changes made by or suggested by Justice Antonio Lemaire. We've also had another independent review, the second one, by former Chief Justice of the Ontario Superior Court, Patrick Lesage. And that too was incorporated with some of the ideas in Bill C-15. His review was in 2011. And more recently, we've got, as General Whitecross alluded to, a major bill introduced by the government, Bill C-77, that has two, again, rather hallmark changes to the military justice system. One is to incorporate what we call the Victims' Declaration of Rights, which is mirrors the civilian Victims' Bill of Rights in the civilian system with some changes peculiar to the military. And it also is introducing a new summary trial process, which essentially decriminalizes and takes the penal consequences out of the summary trial process because of concerns that commanding officers and others in the system are not judicially trained or independent enough from a legal perspective to deal with penal consequences, such as sending a person to jail. So those are major changes. There have been other reports that have looked at the prosecution service called the Bronson Report in 2008, and a later one that looked at the Defense Counsel services. So all this just to outline that no system can possibly be perfect and static. It has to be aware of what's going on in society and in the smaller society of the Canadian Armed Forces. And I think the governments, succession governments, both Liberal and Conservative, have been attuned to that. And certainly the various JAGs, I was included, were very much attuned to making sure the system constantly evolves by seeing what's going on in society, but also what's going on in other militaries, particularly our main NATO allies, how they deal with military justice. So I'm going to leave it just at that, General Whitecross. I'm trying to keep track of time on my end here. And hopefully that provides a little context about this context of modernizing that, it's not something that has to start today. It's been an ongoing evolution, and for the most part, I think quite successful in creating a system that, as Justice Lemaire would say, said in his report, Canadians can have full confidence in the military justice system.
That's a really great introduction and context setting, Blaise. I look forward to the question answering where we could talk about sort of the incongruency or the congruency between taking all these responsibilities away from the chains of command and the leadership throughout the years and strengthening the military justice system. So just some ideas maybe that can percolate on that. So thanks very much. Guillaume, let's talk about the Fish Report.
Yes, thank you, General Whitecross, for the introduction. It is a pleasure to be with you and the other panelists here today. And thank you as well, General Cathcart, for the historical context and the previous cycles of evolution of the military justice system. I think it's undoubted, it's impossible to doubt the fact that the system has evolved considerably, and that essentially the Fish Report proposes a new cycle of evolution in that long evolution. As has been mentioned, I will put the report into context and set out the key principles which were adopted in crafting the recommendations, and hopefully present a few of the main ones, although the report has 107 recommendations, so obviously I won't get into them all, but I'll try to focus on the ones that appear key and that guide a large number of those recommendations. So beginning by putting the report into context, it is important to understand, as General Cathcart has stated, that the review was required by law. It is an exercise that is set to happen every 7 years, and its purpose is to facilitate the continuing evolution of the system by ensuring that someone looks at it essentially every 7 years, 10 years, depending on whether there's an act that is passed, to see whether there's anything that needs to be changed in light of the evolution of the system, of the evolution of the constituency, and of the evolution of the Canadian society, Canadian values. The fact that it's an exercise that's required by law meant that the military justice community was well prepared for it. And we, in crafting the recommendation, Justice Fish had the benefit of extensive written submissions and over 70 interviews with present and former DND and CAF officials, including the senior military leadership, but also with external lawyers, commentators, academics, representatives of victim support groups, and foreign military justice experts. And it's very important to understand that as none of us, neither Justice Fish, another member of his team, or myself, had any previous involvement with the military justice system, it's largely through those consultations that we were able to address and identify the areas which were in need of reform. So going into the principles which we used in assessing the state of the system and crafting the recommendations, there were many, but I can think of 3 that are worth mentioning quickly. The first one is that before being military, the military justice system is a justice system, just like the civilian justice system. And any justice system must be measured by a number of metrics. One of the key ones for the purposes of this discussion is the independence of its key players. There are other metrics such as the overall fairness or the clarity of the prohibitions, but I'll largely focus in this expose on the recommendations that pertain to the independence of the military justice actors. Another principle which we tried to keep in mind is that obviously the military justice system has the purpose of maintaining discipline, efficiency, and morale. However, we wanted this principle to be something actual on the ground. So it's not something that can simply be mentioned to justify any existing difference. We looked at whether there was actually, in fact or logically, a tie between a feature of the system and maintaining discipline, efficiency, and morale. We found that that was not always the case, and in fact, that certain aspects of the system, and the grievance system is one of them, were unconducive in their current state to discipline, efficiency, and morale. So many recommendations are aimed at correcting the situation. The third principle, before getting into recommendations themselves, is that the constitutionality of the system, and which has been confirmed in numerous respects by the Supreme Court in recent years, was not, in Justice Fish's view, the proper standard to use in the context of his review. Simply, in light of the sacrifices that military members are making and the risks they are to expose themselves to, they are entitled to a system that is good and refined and up to date and in line with values beyond what the charter may minimally mandate. And that is something that we tried to keep in mind as well. Going into the recommendations, the first 16 pertain to the independence of the military justice actors. And that has to do, as I mentioned, with the fact that the military justice system is a justice system. Justice is not traditionally an attribute of command. It usually requires a judge to impartially and independently assess the facts and apply the law to them without having any other concern than discharging its duty faithfully and properly. So that requires the chain of command not to interfere with the exercise of this function, and the opportunities for doing so must be reduced. But even before a case gets to the judge, there are a number of military justice actors who also have functions that they must discharge, keeping only in mind the proper considerations, and they must be shielded from interference and from also pressures from their own interests, how their careers might be impacted, or deference to the chain of command, or improper influence from the rank or status of the persons they arrest or try. Definitely, as I mentioned, the system has gone a long way since the 1980s, but Justice Fish was of the view that further safeguards were necessary at this time. I'll deal with military judges and military police. There were also a number of recommendations in respect of prosecutors and defense counsel, which I won't get into, but if there are any questions, I'll be happy to take them. For military judges, Justice Fish recommended that they cease to form part of the military at the time of their appointment. However, they would not become pure civilians in the sense that they would still have a sufficient degree of military experience. In that way, we felt that the system would still be able to function properly while safeguarding their independence. And it's worth noting that this is a recommendation that was largely supported by the Deputy Minister, by the JAG branch, as well as by several members of the military hierarchy. Justice Fish also took up a previous recommendation of Justice Lamère in 2003 and recommended the creation of a permanent standing court-martial, a permanent court-martial, not a standing court-martial. And this may seem technical, but it's not, because the permanent availability of the court allows for its use in situations in many other contexts in the justice system. And indeed, Justice Fish recommended that the court be used instead of commanding officers for the issuance of arrest warrants, for the issuance of search warrants in the pretrial custody decisions, but also in appeal of the summary trial process, so as to offer an independent access to an independent redress following the summary trial process, as it was described as General Cathcart. For the military police, the changes are best understood as compared to the current situation. So currently, the Provost Marshal, the head of the police, is appointed by the CDS and is accountable to the VCDS in the performance of its duties. The VCDS in particular can issue particular guidelines or instructions respecting a particular investigation. And that, of course, has been brought to the attention of the media during the golf course incident of this summer. So to reduce the potential for interference, Justice Fish recommended that the CFPM, the Provost Marshal, become an appointee of the Governor and Council, accountable to the Minister of Defense for the performance of its duties, and that no one have the power to issue particular directions to him or her. Essentially, that places him in the same situation as the Commissioner of the Royal Canadian Mounted Police. Another important change with respect to the military police is the power of any member of the military police to lay charges instead of simply the Canadian Forces National Investigation Service, and also the removal of the unit's chain of command power to decide, not power, but discretion to decide not to proceed with charges laid by the military police, except in the most minor cases. I'm mindful of the time as well, so the last item that I would like to address is sexual misconduct and sexual assault, which is obviously a major topic. Though I'll state briefly the changes that were recommended, and we can discuss them in the discussion. But the key changes that were proposed is that while the Declaration of Victims' Rights is being implemented, and until it is, all cases of sexual assaults that are emerging now should be referred to the civilian authorities for investigation and prosecution, so that the victims may benefit from the rights in the civilian system until they can actually benefit from them in the military justice system. And all of which I've presented so far actually has to do with how cases are handled once they enter the system. But with sexual misconduct, and to some degree with hateful conduct, there's also the problem of cases not entering the system at all because there's a reporting issue. The traditional answer to that has been the duty to report, but it's now largely seen as part of the problem rather than a solution. So Justice Fish has recommended the removal of the duty to report for victims, for their support, for their confidants and support professionals. And to promote reporting is instead relying on measures that we hope will renew confidence in the system and bring victims to report at their own pace and at their own choosing. And those measures include the provision of free independent legal advice by the Sexual Misconduct Response Center, and the strengthening of the independence of the Sexual Misconduct Response Center to actually encourage victims to realize that this center is there for them and not for anyone else in the system. I will keep my comments to that, and I'm glad to discuss any other portion of the recommendations of Justice Fish.
That's great. Thanks, Guillaume. I really appreciate you putting into context and going through some of the major deliverables or major recommendations. Again, there's a bit of a thread there in terms of taking away some of the responsibilities from the chain of command and from the leadership, and then putting them on, you know, the backs of military police and or the military justice system. So I think that's a thread that we're going to try to pull when we come into the Q&A. So thanks again. Leah, up to you, please.
Thanks very much. So my key takeaway here for all of you is that military justice does not exist in a vacuum, separate and apart from the culture of the Canadian Armed Forces. If I can share anything, that's the one thing I'm going to try and reinforce. It's long been accepted that if we look at our civilian criminal justice system, for example, that it reflects and amplifies the social inequalities, systemic anti-Black and anti-Indigenous racism that persist in Canadian society. Despite repeated acknowledgements of the fact, efforts at reform over decades, statutory requirements to take into account an accused's personal circumstances in the context of systemic injustice, for example, it persists. Why? Because our institutions, even our legal institutions, reflect the society that it serves and from within which they are developed. And the same is no less true for Canada's military justice system. In my opinion and in my experience, efforts to reform military justice to make it more equitable, fair, and just will only succeed if we actually see reform of culture of the military and the broader military community. I hope this intuitively makes sense, but I do want to provide a few concrete examples of how the structure, values, and unwritten rules of military culture may create friction and even stymie efforts at reform identified both in the Justice Fish report, but also in the previous reports by Justice Deschamps. So the first issue I want to address is the issue of underreporting, and at the same time, this duty to report that exists when we're talking about really any misconduct, but it's especially prevalent when we're talking about sexual misconduct. Under the DAODs, every member of the CAF has a duty to report to the proper authority any infringement of pertinent statutes, regulations, rules, orders, regulations governing the conduct of any person subject to the Code of Service Discipline. So in theory, at least, victims of sexual misconduct, for example, their confidants and witnesses of incidents are obliged to report those incidents to the chain of command, lest they be found in the wrong for having to fail to live up to their duties. Who can you report to? Well, in the case of sexual misconduct, who you can report to is actually much broader than in other circumstances. It includes a CAF superior of a director general, a commander of a command or formation, a CAF chief of staff or equivalent officer at a command, a CO of a formation headquarters, any other CO or any other officer who can deal adequately with the matter. While in theory, this might be true, I tend to find it highly unlikely that people are really going to report to a senior officer not within their direct chain of command when they are either the victims, the witness, or a confidant of someone engaged who has experienced sexual misconduct, or the MPs. And why do I say that? If any of you have been in the military, I'm sure all you were, if we were in a room together, I'd ask you all to raise your hand. How many of you have heard or had it drilled into them by your superiors, if anything happens, good, bad, or otherwise, I better hear it from you first. I don't want to be surprised. If I'm surprised, I'm going to get upset. This is drilled into us from the very first weeks of basic training. So if anything of consequence occurs, be it at work, on leave, even in our personal lives, we're to tell our chain of command, especially our immediate superior. I don't know how many times I heard, if any of you get pulled over for a DUI, you better call me first. If you get into shit this weekend, you better call me and I better know before Monday morning. If you're attached to another unit and something goes sideways, they better hear about it from you first. This concept of when something significant occurs, especially something of consequence, of wrongdoing occurs, that we have to turn to our immediate supervisors and tell them, is really deeply ingrained in all of us from very early on. And if you happen to hide something, if you keep that stuff hidden and anyone finds out later, there's going to be a world of hurt. I can tell you that this is so deeply ingrained that I had a boss who told his superior officer about a divorce before he told his children. That was very, very common. So when we think about this duty to report and who we can tell, right, we know when it comes to sexual misconduct that only about 25% of regular force members in a survey taken in 2018 who were sexually assaulted stated that someone in their authority found out about the incident, and 57% said nobody was aware. And when you think about that in contrast to this duty to report, and in contrast to this idea that if anything happens of consequence, you're supposed to tell your supervisor, I think you can start to see why. And I think I just want you to imagine a young soldier who's been the target of verbal sexual harassment by a senior NCM in their unit. If they want to report that behavior, who will they approach? Will they go to the DAODs and see who the superior officers are across their base that they could potentially report to? Will they go to the MPs? I think that's highly unlikely. We're trained to go to our immediate supervisors and talk to them. It's how the military functions in so many respects. But that person is going to look at who that person is, and they'll question whether they trust them with that information. And if you have an NCM or a senior NCM or junior officer that you're supposed to be reporting to, and you've seen them in the past laugh at sexual jokes, make sexual jokes, turn a blind eye to bad behavior before, are they friends with the person you're reporting on? Are they allies? Have they served in the shit together, right? Do they like you? Do they think you belong in your unit? All of these things are going to go through your head when you're deciding whether or not you're going to trust that person. And trust is incredibly important. The relationships between superiors and subordinates are incredibly powerful, and they demand trust. And you need to trust, as a victim of sexual misconduct or sexual assault, that the person you're telling is going to act on your behalf. And I really think that has a huge impact on the likelihood that someone's going to report. So just the general nature, the general culture of your unit, how that unit functions around issues of sexual misconduct or other hateful conduct, what the general nature of the unit dynamics are like, will have a huge impact on whether someone feels that they can report to their chain of command. And I do think that they will seek to report to their chain of command rather than seeking to report elsewhere, because that's what we're taught to do. This notion of going elsewhere to report is just such an anathema from everything else we're taught when we're in the military. So those two things work hand in hand. And if you don't report, the military justice system never has an opportunity to even kick in. And the duty to report, as I said, includes not just victims. We're also talking about anyone told about that misconduct or who has witnessed it. But you need to perceive a specific action as misconduct for you to feel like that duty has been triggered. And I will tell you from my own experience that after years of service in a highly masculine and somewhat toxic, sometimes toxic environment, that my own perception of what qualified as misconduct was radically different from what in truth meets the definition under the DAODs, which to some extent are somewhat subjective. I can tell you, as a junior officer, when I was given the privilege of serving as a 6-0 troop leader, which was a big deal as an armored officer, I got to be recce troop leader for the brigade. My office, which I got my own office, came with a box of pornography that sat under my couch. That was a privilege. And it was a privilege to have troops come in and want to hang out in my office because that office was known to come with pornography. And I accepted that as part of the perk of the job. I thought very little of the fact that men around me were ogling and objectifying women in front of me. I routinely laughed at jokes made at my own expense that demeaned other women or just generally disparaged other women. And this was my perception of what was acceptable and humorous as a young female officer. How were the men that were also involved perceiving what was acceptable and not acceptable? How was my behavior also reinforcing what was acceptable and unacceptable when it comes to sexual misconduct? I know that to some extent the times have changed, but those serving in senior ranks now grew up in that environment. So if you don't perceive misconduct as misconduct because the cultural environment accepts certain behavior as normal, right? What are the chances that they're going to report it, much less take action against it? The last thing I just want to speak at the point of view of an accused and a victim facing the military justice system. And I'm talking more here about the summary trial system rather than the criminal justice system, although I do think that they're important linkages. I was both a victim of sexual assault and myself investigated and charged with sexual misconduct during my time in the military. So unfortunately, I have a bit of experience here. And I'll say that for me as a woman who felt like an other inside the military, it was incredibly challenging to advocate for my own interests when sitting across from a superior, either when you're in trouble or you're asking to make trouble for others, especially when you feel that your just essence is unwanted in the organization because you're different, because you're a woman. You learn early on as a woman in the CAF to make the fact that you are a woman, your very existence, as little of an inconvenience to others as possible. I suspect that that may be different now, at least in some trades, but in the combat arms, I did everything in my power at all times to make the fact that I was different as unnoticeable as possible. And if it was pointed out in the negative, I would apologize and give others the space to complain or joke. That behavior became deeply ingrained in how I existed within the Canadian Forces. So when I was faced with my own accusations of misconduct, I did not advocate for myself or assert my own rights. I tried to make my existence and the existence of my mistakes as tolerable to my superiors as others, to make them go away for them as soon as possible. I sacrificed my own rights to a fair process because I was so ashamed that I had become a problem that I did whatever it was to make it easier on everyone around me to make it go away. I don't believe I'm alone, but I think that has huge implications for both victims and accused. I might have been informed of my rights, I may have known my rights, but I wasn't willing to assert them because of the culture I had grown up in, because of what I understood my job was as a female in the Canadian Armed Forces. So I didn't even think about ensuring that I was treated with fairness, transparency, and that I received justice. If victims and accused don't feel comfortable asserting their rights afforded to them by the military justice system because of the culture of the CAF, it really doesn't matter how fair of a system we build. This is why building a safer military justice system demands building a safer Canadian Armed Forces for all members. And I really believe culture change is at the heart of everything. Thanks very much.
Thanks, Leah. That's brought back a couple of memories on my own side. So folks, it looks like a lot of the threads that are coming through here, especially in the questions and answers, as well as your comments, really have to go to the heart of leadership, the heart of the chain of command, and how people are on one side being treated or not, and on the other side, responsibilities being taken away from them and then put onto other systems, military justice system, for example. So I would be interested to hear your comments, Guillaume and Blaise and Leah, on those responsibilities that are being taken away from the leadership, and how is that adding to the effectiveness of the Canadian Armed Forces in terms of maintaining the responsibilities for discipline, deportment, and troop morale within the chain of command. And on the converse, what is it that we can do in order to build up the chain of command so that they are making the right decisions and that they can be at the forefront of supporting in a very dignified and respectful way the people that serve under them? Who would like to go first? Nobody. Blaise, thanks very much.
Thanks, Chris, and Guillaume and Leah for those great comments as well. Well, this is a very easy question to answer, Chris, that we only have an hour left. I think I can use all that time. No, it's classic in military justice because it is a separate system where that historically was based on the chain of command being in charge of it all. And that was, and actually today still remains, a very valid and necessary point. Why? Because certainly in our societies, modern democratic countries with modern militaries, they invest the commanding officer with incredible responsibility and pressure, up to including decisions of life and death over the young men, women, and others who serve in the military. So on the one hand, the country is asking commanding officers at all different levels to say, you're in charge, you make the decision who lives or dies. To put it in blunt terms, that doesn't happen each and every day, but it happens frequently, particularly on operations. And on the other hand, when it comes to justice, as Guillaume has pointed out, and I disagree slightly, I agree that justice is justice. But the point that I think a lot of scholars and commentators and people who look at the systems, including independent reviewers, they look at the military justice and they jump immediately to the concept of justice and don't pay as much attention to the military portion of it. And that, what I mean by that is, why is it separate? As I talked about before, it's all about discipline. Who's responsible for that? The chain of command, the commanding officer. So every time, whether it's through a military justice change in court martials or summary trials, or even more broadly, as Guillaume was talked about in the Fish report about things like the grievance system, every time you want to introduce an external body, whether that's external to the chain of command within the military or external outside of the Canadian Armed Forces altogether, you're eroding the commanding officer's authority and responsibility. For what purpose? And this is the point. It's not simply to look at, let's say, the rights of the accused and make the system, respond only and solely to the rights of the accused, or more, in the more modern age, also the victims' rights and what's important for victims. You have to keep in mind the military chain of command, that's because they still have to take the young men and women and put them in very life or death situations. So the more, in my opinion, the more you erode the commanding officer's ability and the chain of command authority, the more that you're creating real gaps, I think, in the ability to maintain that discipline, that habit of obedience that I talked about earlier. The flip side, as Lee has talked about, is if those who are being led by the chain of command don't have trust in it, and that trust is not usually limited just do they trust military justice or not. It's much broader and more times than not. It's, do they trust their leaders to look after them in a basic way? And that's the real challenge. And I personally still want to make sure we give the chain of command its opportunity to make things right, if you will, in the evolution of things like military justice. That also applies to just basic stuff, how we train our troops, how we recruit them. The chain of command has to be a key player in that. And you've got to be very, very cautious, in my opinion, of looking quickly or too quickly to saying, well, we should, civilianize aspects of military justice, as Justice Fish has said in things like the, military judges should be civilian judges, or military police separate from the chain of command. I think you have to do a lot more deep dive research and consultation, not only outside the CAF, but inside the CAF, to find a better a balance, if you will, of what works and what doesn't work. That's, for example, we did that, as I mentioned, in this concept of Bill C-77, which was introduced by my successor, Rear Admiral Bernatchez, and the government. I had introduced it as Bill C-71, and it died on the order paper, of this concept of switching from a summary trial to what we call a summary hearing, which is more administrative in nature rather than having hallmarks of criminal law attached to it. Some may see that as, again, a gutting of a commanding officer's authority over the troops to enforce discipline. Let me be clear, none of that was done without full consultation with the chain of command. And I say chain of command, both being at the highest levels, right down to senior NCOs, coxswains of ships, regimental sergeant majors. They were all fully consulted over a year period. And interestingly enough, in terms of this concept of taking penal consequences away from the summary trial system and commanding officers, that was fully supported. It was, I personally, as JAG at the time, I was quite shocked. I thought it would be a real uphill battle, but commanding officers were aware of how it was, being used. For example, annual stats in the JAG annual report showed that at summary trial, commanding officers only use the power of detention less than 1% of the time each year. So what's the point? Especially since sending someone to detention attracts, from a justice perspective, a lot of that unfairness that Guillaume and Justice Fish are referring to, where you have commanding officers who are not legally or judicially trained. They might have biases. They're not independent enough from a justice perspective. But when you look it down, and most of the senior members, including the senior NCOs that I just referred to, they felt that in the modern 21st century military, things like extra drill or fines or confinement to ship or barracks, those were much more effective to the young soldier, sailor, air person, and special forces trooper than detention. And from a legal perspective, I think it was very wise to move away from those criminal aspects, including a criminal record from a summary trial, which would follow someone their whole life. Because I think eventually, whether it's a court martial or the Court Martial Appeal Court of Canada, which consists of civilian judges of the Supreme Court of Canada, would eventually tell the military, you've got to change this summary trial system. So we were proactive in doing that, and but not at the expense of looking to gut the chain of command of having its responsibility still to maintain discipline and to take care of the troops. So we had to make sure that the chain of command was fully engaged in that aspect. When you look at other aspects, these are much more complex and technical for virtually every Canadian Armed Forces member, including the chain of command, and that's the court martial system. And that, because that is where the more serious offenses occur, and they are clearly, more scrutinized in terms of a court martial appeal court or even the Supreme Court of Canada. That's the area that it's difficult to have the chain of command as involved. And to be frank, when I dealt with a lot of senior officers, they would, kind of get glassy-eyed when you started talking about the legal aspects that you would find, say, in the Fish report. And many would say, well, it's not our system, JAG, it's yours. And I would push back very strongly saying, no, this is the military justice system is for the military and chain of command as a tool to maintain justice. The JAG only helps you to supervise it and make sure it's constitutionally valid and create justice policy that will keep it evolving into the future. So from that perspective, again, it's by nature the way you have to ensure rights of people like the accused and victims. You do have to, as a matter of necessity, start to take the chain of command away from some of the key decision players. Having said that, it's still vitally important that those players that Guillaume talked about, in my opinion, the military judges, the prosecutors, defense counsel, and the military police, I think it's critical that those people still remain military people in uniform to ensure that the military justice system is reflective of the appropriate way to maintain discipline. The concept of discipline, in my experience, is not one logically that is well known or even cared about, frankly, by most of the civilian population, but it's everything to the military. And having as many people who understand military life and operations who are able to have a stakehold in this, I think is absolutely critical. If you start to civilianize it, then it's not military justice anymore. It's simply civilian justice that takes on a military arm somewhere in the system. And again, that would even more alienate the chain of command from having a role, and an important role, in those life and death decisions and command responsibility. And I'll end it there.
Thanks, Blaise. That was a really good start. Guillaume, do you have something you'd like to share on sort of counterpoint?
Certainly. Well, first, I have a couple of points, actually. So starting first, maybe with the overriding role of the commanding officer in the whole military world, I wish to clarify that it is definitely not a question of distrust in the commanding officer. Quite to the contrary, I believe that Justice Fish has been very impressed by the commanding officers whom we've met in the process, including in town halls. And even presuming that all of Justice Fish's recommendations are implemented, I wish to clarify that the commanding officer still retains a very important role in the military justice system. And to cite a few examples, the commanding officer still has charge laying authority. He still has the power to coordinate a unit disciplinary investigation. He still has the power to conduct a summary trial in virtually an unchanged way, except that there would now be a requirement to provide written reasons and the potential of an appeal. But if we look at other similar systems, such as the UK and New Zealand, where there exists and has existed for, I believe, more than 10 years now, an appeal to a summary appeal court, this possibility has proved very little disruptive to the overall summary trial process. As a result, perhaps, of cultural issues, such as Dr. West has mentioned, that most soldiers just want it over with and don't necessarily want to assert their right to a fairer process in many cases. We've also been told by in the town halls that many people who choose to proceed by summary trial do so when they know they're guilty. So they don't necessarily have an interest to go into appeal and to make the process longer. The percentage we've heard is about 5%, if I recall well, of cases in the UK and New Zealand end up going in appeal, which is not disruptive at all, in my opinion. And just to finish my list of things the chain of command can still do, even when a case goes to the court-martial system, there can still be open communication with the prosecutors as to what discipline might require in a particular case, especially when the infraction is a broader one, such as prejudice to discipline and under Section 129, or such as what punishment may be appropriate in the particular context of that unit. But I think it's important to look at what is actually the exercise where the portions of the military justice system from which Justice Fish is recommending to withdraw the chain of command. They're essentially questions of law. So the decisions that judges must make, the decisions to lay charges or not, and appropriate punishment. I also want to mention, in response to the concern that the system may not be reflective of a military life or the military discipline, that it's a very small change that is being recommended. In terms of judges, they would not be civilian judges in the sense that we take any judge from the Superior Court of Quebec or of Ontario and we have them adjudicate military cases. What was recommended is essentially the same thing as now. Someone has had a long career as an officer or non-commissioned member in the forces, but upon being named as a military judge, as he would or as she would, that's when he or she renounces the military status in order to be able to take any decision without any potential for influence from the chain of command, be it real or solely apprehended, because in these matters, the appearance of justice is very important to maintain the legitimacy of the system in the eyes of the people that are subject to it. I just want to add that such civilization may also have benefits. And this ties into the cultural issue that Dr. West has mentioned. When every player in a system is able to act independently, truly independently, without having to keep in mind how senior people may perceive the same issue, it allows a certain fragmentation of a culture. Because if you have to take into account what other people might be thinking, you have to think of their culture as well, not only of yours. And also when you have such a civilization, if you will, it allows ideas to come from outside, and I think this is very much in the spirit of the time, the zeitgeist. General Eyre recently, when he put an end to Operation Honor, stated in a letter to all members that he fully acknowledged that when it came to sexual misconduct, the military did not all have all of the answers and would welcome outside support. So I think this is actually an occasion for these external ideas to enter the system. I think that would be, this is essentially what I had to say, but I'll be glad if there is any further discussion or questions on the topic to take them.
Thanks, Guillaume. We'll let that discussion go a little bit further. in a moment. Dr. West, anything to add?
Those were very broad and overarching remarks to the issue of leadership, and I'm going to bring it back down to one particular issue. One of the recommendations in the Phipps report was to take all allegations of sexual misconduct out of the chain of command, except for very minor cases, which is undefined. I do think that sexual misconduct allegations should actually remain within the military justice system, in the summary trial system, because I think in order to change culture, justice needs to be seen to be done quickly. Discipline needs to seem to be done quickly within the chain of command. So I think people, in order to understand that a change of culture is arising, when there are allegations of misconduct relating to sexual misconduct, it needs to be dealt with swiftly by the military chain of command. There needs to be discipline, and everyone needs to be able to move on, just like any other issue. And I only think then are we really going to start to see a trust and understanding that this kind of behavior is not tolerated. The idea of seeing justice done within the chain of command, within the ranks, is incredibly important. That swift justice and return to discipline is important, just as much with sexual misconduct as with any other issue.
I can just step in. I don't think that's exactly the recommendation, because the recommendation, as I see it, is that sexual misconduct, except in the most minor cases, should not be investigated by unit disciplinary investigations, but should proceed by military police investigation, simply because unit disciplinary investigations would not have the same hallmarks of independence as the military police investigation would have if the changes are implemented. But definitely they could still proceed in the summary trial system, provided they can now do so, or in the summary hearing system eventually, because it's likely that there will eventually be sexual misconduct offenses, which will go to court-martial system, and sexual misconduct infractions, which will go to summary hearing. There's actually a recommendation that that the JAG consider extending the victims' rights also to the summary hearing system in that context. And as I think it's very important what you've mentioned about the necessity of justice being seen to be done, and that I think is also the spirit of the exception of the most minor cases, because as you've mentioned earlier, sexual misconduct is very broadly defined, and it extends from on the most serious side, sexual assault, which was already an offense in its own, and in the less serious side, to simply words, degrading words, or sharing of obscene material or explicit material or jokes. So I believe the spirit of that exception is to capture precisely what you've mentioned.
Thanks. If I can just ask a question, and then perhaps we'll just go to final points, because we're almost at the end of our hour and 50 minutes. And that's, if we allow military judges, or we require military judges to put aside their military part to them, and then they become judges writ large, what stops the precedents from going further to allocating judges to those slots without military background? I guess that's my question.
Well, if I can, according to Justice Fish's recommendation, it's actually you have to take them all together. So the recommendations would only alter this portion, but they would leave in the NDA the requirements for having acted as an officer for 10 years, being a member of the bar. I think there's also a recommendation that it be amended to include non-commissioned officers having 10 years of experience. So this would be what would prohibit the fully civilian judges. Of course, if there was to be an amendment to the NDA, it will now become possible, but I think that there is no recommendation to go as far at this juncture of military history.
Okay, thanks. Blaise, you have a comment?
Yeah, well, I think that, I think the short answer is, once you start, I still call it civilianization, because if I understand that the fine point that Justice Fish is making, that they are not people solely without military experience. They had been in the military until they're appointed as a military judge. But that to me is a very slippery slope, not only for future of judges, but I think the same logic starts to have to apply to prosecutors, defense counsel, court martial, administrators, even military police, where you say if military police, who by the way are unique in all of Canada, unlike the RCMP, who have their primary policing and some security roles, the military police are unique in that they're both members of the military and can do non-policing activities, such as detainee handling in Afghanistan, but are also responsible for policing. So I think you have to, again, look at the uniqueness of the military justice system and the players and stakeholders. And I think if you're focusing on the military judge, sure, they will have that experience up until they're appointed a judge. But after that, where did they get their experience? The military will evolve. And what will they know about the military if they're not really members of the military in that going forward, perspective? And I think you can have confidence that people can still be in the military and judges. We've had recent court-martial appeal court cases called Edwards and Proul, where a unanimous court-martial appeal court said, yes, of course, judges can be both military and be able to deliver independent justice. And that's another longer conversation that I could certainly have with anybody about what is independence in this context, because it's not a clearly defined term, even in the civilian context. So I think yes, there's a slippery slope. And in a practical sense, having a cadre of judges who become non-military but still somehow have military experience, currently the stats are about 40 courts martials per year on average, and maybe less than half actually go to full trial. These judges would have nothing to do, to be honest, outside doing a couple of court martials, and they're not learning anything more about military culture while they're outside of military culture. So again, these are ideas that need to be considered and debated, but my experience has been there's far too easy a movement to say, what currently exists is wrong, or even in a positive sense, Justice Fish says it's constitutionally, it meets the minimal requirements. I disagree with that. I think it goes beyond minimal requirements constitutionally. But then you run the risk then of becoming over the top. You're over engineering a system. You're essentially going to turn it into a civilian system, and that continually begs the question, why do you need a separate system? And certainly the courts and the Supreme Court of Canada have not gone anywhere near that thought. They believe strongly in the independent, fair military justice system that is populated with people in uniform.
Thanks, Blaise. And I'm really sorry, folks, but we're actually toward the very end of our time. So I'm going to offer our three panelists the opportunity to make some final comments, and then unfortunately we're going to have to close. So we'll start with Dr. West.
So I just, as a lawyer, I work with a criminal defense firm. I study the law, study constitutional law, and I was a former military member, not a military justice expert. But in reading the Fish report, all of his remarks make sense if you're a civilian. And I do think that there are some recommendations that are about making a system more similar to a civilian system, but I don't see to what end necessarily in every case. I don't see the end being correspondent to the aims of the military justice system. And I do think that that's why it is important to step back and assess the recommendations with, yes, this would make the system more impartial, more independent, but what else are we losing? And I think that question of what else is lost, and not necessarily Justice Fish's place to assess that, But I think before implementing every recommendation, that needs to be considered, because I don't think that because of the current crisis the military is in, the appropriate measure is to just implement all recommendations from external reviews without thinking through what else is lost when it comes to military command control and military justice.
Thanks very much, Leah. Mr. Charlebois, please.
Yes, I think speaking from a civilian standpoint, this is exactly right, but we must also wonder what is gained by the current status of the system. And I can assure you that in drafting the report and in crafting the recommendations, Justice Fish wanted to ensure that there was no impact on the basis of what he was being told on maintaining discipline, efficiency, and morale. And so in cases where a recommendation has no impact on the purpose of the military justice system, the default rule seems to be the equality of citizens in Canada before the law. And I can also assure you that these recommendations were highly thought of. They were discussed with the military hierarchy. Judges in particular, I've mentioned that they received the consensus of the senior military hierarchy, but if I can be more explicit, they received the support, as I mentioned, of the Deputy Minister, JAG, the heads of the Army, Navy, Air Force, Joint Operations Command, Special Forces, as well as a substantial portion of the people who appeared in the town halls. Definitely, it is but one means for the system to evolve. Definitely, new facts can come up. I think it is important to keep these divergent assessments in mind, and ultimately, as to the implementation, it's up to the military justice community to weigh the benefits of these recommendations, of these suggestions against the current situation, and to press for their implementation or to militate against it with the appropriate deciders. Thank you very much for attending today and for your interest in military justice.
Thanks very much, Guillaume. And Blaise, last comments, please.
I'll be brief, which is dangerous when a lawyer says that. Yeah, I guess I would just like to leave a message for those tuning in who maybe have been in the military, are in the military, or thinking about joining the military, that you be confident. The military justice system is modern. It continues to be modern. It continues to modernize. As I said earlier, it's not perfect. Neither is the civilian justice system. And when you're looking at specifically, topical matters, important topical matters, like Leah referred to as sexual misconduct and sexual assault, it can be very frustrating. But as she says, you have to look at the military and be able to separate, is it inherently the military justice system that's problematic and causing these problems as a primary source of the harm, particularly to victims? Or is it a good, practical, logical, functioning system with the proper degree of independence and what I call functional independence for prosecutors, police, judges, and defense counsel? Is it functioning properly so that people can have the confidence? And I think the confidence is there in the system and should be. Where I think it's lacking literally today is we have a crisis in leadership. When you see more than one chief defense staff, current, former, senior officers. Many of these are allegations that are historical in nature, but nonetheless, they are very real to people working and being members of the Canadian Armed Forces, or people considering joining the Canadian Armed Forces. And I'm hoping that this CDA panel has provided some information for those people, so that they can start to form their own more informed opinions about specifically military justice and whether it's modern or not. And I say it very much is. And is it malfunctioning, if you will, because of the crisis in leadership? And I think right now that's more of the problem than not. And that's just not limited to military justice. You have a crisis in leadership, all aspects of military command are then questioned as being trustworthy or not. I think military justice as an institution has built up credibility and continues to do so. And I think it would be very, very risky business to proverbially throw the baby out with the bathwater by simply saying the better solution is civilianization. I know personally a lot of victims of crime in the civilian system, sexual assault crimes as well, and they're not overly pleased with the way they were treated by a system either. But I think the difference for the military is that command function and the maintenance of discipline, and we have to earn the trust. And I think if we get the right culture and leadership, as Leah has mentioned, I think the criticisms of the military justice system will be reduced to the more technical matters that Justice Fish has focused on. And thank you all for listening and hopefully being patient with the comments.
Thanks very much. Major General Cathcart, Mr. Charlebois, and Dr. West, thanks very much for your commentary and your expertise on the subject. It's obvious that from the questions and from the deliberation that there's a lot more that we can be discussing today, and it is a complex issue. I think that it really is important that the senior leadership, certainly on the department side and the CAF side, really come together for in the discussions phase. So thanks very much for coming on the panel. And I'm sure this is not the only time we'll be discussing the military justice system. Thanks very much.